We're going to talk about the right of publicity now. You're going to see that this intellectual property really overlaps copyright law. The legal term is called appropriation, where you're taking a person's name, picture, photograph, or likeness and using it for commercial gain without permission. So you're using somebody's name, picture, or likeness, point one. You don't have their permission, point two, and you're using it for commercial gain, point three. You need all of those three things. And under the umbrella of appropriation are two categories: the right of privacy and the right of publicity. Right of privacy is protecting a individual's form of emotional damage that can occur when somebody uses their name or likeness. This is usually for any individual, not just a celebrity or somebody with high status who also gets to claim. They get to claim right of privacy, but you and I can claim it too if somebody uses our likeness to sell a product and they don't have our permission. And that would be a claim for right of privacy. Right of publicity is the economic harm that compensates individuals for their loss economically with the use of when somebody uses their name or picture for advertising purposes without their permission and they didn't get paid for it. That's right of publicity. That's the umbrella we are going to talk about here. So obviously what comes under the umbrella of right of publicity, who falls into that category? Celebrities, right? Why do we have right of publicity? Would you buy a product that might have a celebrity's name attached to it? A lot of people do. Like, Michael Jordan. Then buy a product because Michael Jordan, quote unquote, endorses it. So they have a legal right to protect that identity and to make money off of that. Right of publicity is a state law, which means it differs from state to state. And it's not a highly developed area of law unless you're in states where there are a lot of celebrities. New York and California, for instance, have the most developed area of law in right of publicity because that's where most of the celebrities are. Before we move on to use and name and we start breaking down the elements, I just want to hit a couple points relative to this right of publicity. It is an intellectual property right, and its interest can be freely transferred, and a celebrity can license that use out. That's how it would work. If you wanted to use Michael Jordan to promote your product, you would have to go to Michael Jordan, his business, his entity, and seek permission to use his likeness. Now with the other intellectual properties that we talked about, patents and trademarks and trade secrets, those things, and we didn't talk about them individually there. I'm bringing this introduction in right now and it'll continue through copyright. Once you have those things, remember that trademark, it can last forever as long as you continue to register it and use it. Trade secret, the same thing, as long as you keep it secret and you continue to use it. It has a lifetime duration, and our patents have a 20-year duration. Now, if you have a patent, a license for a patent, and most of the time, those three things are owned by some business entity. And if something happens to the owner of that business, those licenses continue to pass along with the business. Well, let's say you individually owned a patent, just you. You created some great software and it's yours, which any person can get a patent if you have an invention, and you license it out. If something happens to you, you die, where does it go? Just doesn't go poof into the public domain. If we're still within the 20 years, it will pass to whoever your heirs might be. Same thing happens here with right of publicity. If a celebrity dies, is it fair game? Kobe Bryant passed away. Is it fair game to be able to use his name and likeness now? The answer is it depends. Depends on which state you are in. Every state has, like I said, different laws regarding right of publicity, and this is one of those areas. Is it inheritable upon death to heirs? And it's going to depend on the states. Most of the states have them. California is the first one to adopt such a rule that a right of publicity transfers on the death of the celebrity. The extension is 70 years. Tennessee as well. Tennessee is home to a lot of Nashville artists, but more importantly, Elvis. That's kind of where that stems from when these laws were being created. New York, oddly enough, does not recognize the right to that right of publicity to transfer to heirs. And right now, there's a lot of legislation going on trying to get that to pass. Which really stirred the pot on this issue was the passing of Prince in Minnesota, who did not have that kind of law in place. And so I'm free to use Prince's likeness now after his death. So the key component will turn on where the celebrity lives. That's going to control the duration. So if a celebrity residence is in California or Tennessee, then the heirs will have that protection. If the celebrity was in New York or Minnesota, it's not there. So something to keep in mind relative to these rights, because it's an economic value. But just because Kobe Bryant or Prince have passed away, or Michael Jackson, there's still some value in those names and likenesses. Now, there's only one Supreme Court case that has put some bite into this right of publicity, in recognizing that it exists. There's a video link I would be showing to you in class. It's a couple minutes long. It's the Zucchini case, and it's the human cannonball. And without watching it, you're going to know that somebody's in a cannon and being shot out of it. That was entertainment back in the day. And they did this family, this Zucchini family did this as their business and their lifestyle. And what happened was CBS televised the broadcast of the entire thing at the fair in Ohio. And the family sued CBS saying, it's a right of publicity. That's my right. That's my living. And you can imagine what CBS said. Communication majors, right? News, it's news. We're just delivering the news. And we're protected by the First Amendment right of press, right of speech. And the Supreme Court said, well, that might be true. You have the right to free press and free speech news organization, but what you did was you aired the entire show, the entire thing, which if people could sit home and watch it on TV, why would they buy tickets to go see it? And how would this person this is how they make their money. So the Supreme Court kind of poo-pooed the right of free speech. And more familiar, let's bring it more to date, is can news organizations report on such events? Of course they can. What do they usually do? If there's a concert in town and they want to, say it's a big news story, Lady Gaga's playing in town, there might be a news person down there, there might be a photographer down there, they might snap a picture too. They get like a two-song rule, and they get up front and they can get some press, but they can't record the whole show and broadcast it, right? So I just wanted to note that it is recognized by the First Amendment, and take a peek at the actual video. It is the broadcast that CBS broadcasts. It lasts like less than 2 minutes. So let's kind of go through these elements here. Use of name or use of likeness. What constitutes the use of a name, and what constitutes using somebody's likeness? What counts? What counts as a name? If I said the name Reginald Dwight, if I said the name Sean Combs, you might recognize that one. Those are entertainers' real names. Reginald Dwight is Elton John. Sean Combs is P. Diddy. Lady Gaga, it's not a real name. Stephanie, and I always forget the last name. It'll come, Germondo? You guys probably know, but we'll Google it. By the end of this, it'll pop into my head. But Lady Gaga is not a real name. And those names, those stage names, those pen names, the names they go under that make them famous are protected. Those are protected names, even though they're not their real names. What about business organizations? Are those protected under right of publicity? Lego, Kodak, McDonald's? Those count? No, those do not count. The right of publicity is only for a person, an individual, not a corporation. It's an individual right. What do those things have? They have trademark protection. Trademark protection. Don Henley. If you're not familiar with Don Henley, he was in the band The Eagles. Also had some solo act. He sued a clothing store for having this ad in their flyers, Don A. Henley. And it's a nice play on words. A Henley is a form of a male's shirt, and that's what it looks like. So when you see a shirt like that, they're kind of out and about, so you can say that's a Henley. And he sued, and the court said, yeah, a play on words is a use of a name. Donna Henley. No can do. Let's talk about likeness. What if you use somebody's photograph? What about a photograph? That's kind of obvious. If you use a photograph of somebody, you got to ask how old is the photo? Does it matter? Does it matter how old the photo is? Does it matter if you use a young picture of Brad Pitt than the 50-something-year-old Brad Pitt? That doesn't matter. And it doesn't matter. It doesn't have to be their actual face, as long as they can be identified and recognized. There must be a clear representation of the features, the identifying features of the individual when you're using a photograph. What if you don't use their photograph, but what if you draw it? What if you draw it out and you draw it and you sketch it? Kind of like how magazine did with Muhammad Ali. And they don't even say his name here. They just say Mystery Man. You know, he's the greatest, quote unquote. They make kind of reference to him, but they, cartoon image of him butt naked in the magazine. They titled, like I said, they titled it. They never use his name. Does this count? Make sure this is a New York case. Yeah, you can't sketch somebody. You can obviously tell who it is. As long as you can identify them, you're not going to be able to use that likeness. What about lookalikes or soundalikes? This is a big business that businesses like to do with a celebrity. They don't want to pay a celebrity, but let's get someone that looks like them. Does that work? We didn't use your likeness. We just happened to use this other person. Maybe like them or not, looks like them. In this case, you recognize these two individuals. The one, if you're facing the screen, the one on the left with the white background, Kim Kardashian. The other young lady, her first name's Melissa Meliano, I think is how you say her last name, Meliano. She was in some reality shows and some offbeat B movies. Melissa was in the Old Navy commercials, and that upset Kim Kardashian. She thought it looked like her. They made her look like Kim Kardashian. So Kim Kardashian sues Old Navy, claiming that they used a lookalike trying to sell their clothes. And while the case wasn't decided by a court, it was settled out of court for a cool $20 million. Old Navy paid Kim Kardashian. Whether you think it's lookalike or not, maybe if you're sitting on the jury and you saw the pictures, they'd probably show you the commercials. I couldn't come up with the commercials. Lookalikes, no can do. Can't do lookalikes. Actually, the first case that about impersonating a celebrity in advertisements will violate the right of publicity. was Jackie Kennedy Onassis. Jackie Kennedy Onassis was married to JFK, President JFK. In 1984, she brought a lawsuit because of the use of somebody that looked like her in an advertisement to sell designer products. So, no, you can't use an impersonator, somebody that impersonates or looks like them. But what about sounds like them? What if they sound like them? What if you're a business and you like a great song, and you don't particularly want to hire the singer that actually sings the song to sing it, but you hire somebody else that might kind of sound like them to sing it? And that's what happened in the Bette Midler versus Ford Motor Company case, where Ford hired a singer that distinctly sounded like Bette Midler and actually used a song that Bette Midler was singing and sings to impersonate her, or to use her distinctive voice in their advertisement, and Bette Midler sued. And some of the facts that it turned on was things like, this gets a little down the muddy water lines, just based on that. If you just get somebody else that sings somebody else's song and they sound like them, does it create the illusion that, oh, it was Bette Midler singing the song? But some of the facts that came out that made the courts determine that, yeah, if you get a sound-alike that sounds like the actual singer without their permission, you can't do it. You can't do that. The facts were Ford Motor Company. There was evidence that Ford Motor Company asked Bette Midler to be in the commercial and sing the song, and she said no. So they sought out a license for the song through a publisher. We'll talk about all that in copyright. And got somebody else to sing the song that sounded like her. Like that was an intentional, that signaled that was intentional, because they wanted Bette Midler and they didn't get Bette Midler. And so they kind of went about it the wrong way, obviously, from what the court said. What about a disclaimer? Would a disclaimer help in advertisements? This is not Bette Midler singing. This is not Jackie Onassis. This is not Kim Kardashian. If they did that, sure, actually they would, but it has to be obvious. It can't be some fine print in the small. It has to be seen. And it can't be, if it's a voice saying, this is not Jackie Onassis, it has to be heard. It can't be just buried in the music. So yes, you can use a disclaimer. What about, we're still on likeness, name and likenesses. There's a lot to it, and you got to think about these things if this is what you're going to use when you're creating your copyrighted material, whether that be a news story, a documentary. We'll talk about songs in a moment. Maybe you're trying to expand on photographs, using Photoshop, and you have characters in it that you might have taken from someplace else, like television characters. And that's what we're going to talk about now. Does protection of a celebrities extend to their characters that they play on TV and movies? And I'm going to give you the question here, and then I'm going to switch to some pictures. The question is whether the actor had become so identified with the character that the use of the name in a commercial venture would invoke the actor's own image. This seems to be more towards television characters, because television, those long-running TV shows, where that's where the person is known for, you see them anywhere else, and you're like, hey, that's so-and-so from this TV show, right? I mean, think about some of the shows you watch. Big Bang Theory is one of my favorites, and I couldn't tell you any of their real names, but if I see the character who plays Sheldon, I'm like, they're Sheldon. They're so ingrained in us when they're a long-running show. So the question is whether the actor had become so identified with the character that the use of the name in the commercial venture would invoke the actor's own image. Now, this was a case that did that. This might be a little old for you guys. This is the case. And when we go back and we were talking about precedent early on, because sometimes I've had students say, why are we talking about all these old cases? Because they don't change. If that's the law is the precedent. And unless there's some different sort of fact related to the case, or something out of the ordinary, or something that appears to be obviously wrong, cases aren't going to be brought because the decision was already decided. So all of these issues we're talking about have been decided. You can't use a lookalike, you can't use a sound-alike, you can't draw a person's likeness to get, so all of these things have been, well, if I can't use their photograph, maybe if I draw them, that would be good, and then that gets challenged. So they don't get revisited every year just to make sure they're okay. So unfortunately, they stem over time from creation. Right now, some of the new laws involve the social media, and we'll see more newer laws when we're talking about copyrights, because that's really stirring the pot with the advent of the internet and being able to and Photoshop and things like that. But some, these cases, and this is not that old, 1997, it's really not that old. So these folks are from Cheers. If you guys watching the reruns of Cheers, or maybe you grew up watching Cheers because your parents were watching Cheers, Norm and Cliff. These, George Wendt is, and I don't know, see, their real names has always escaped me. I know them as Norm and Cliff. And if you see them anywhere else, and aside from like Lifetime movies, you associate them with Cheers. So what happened was this bar decided to get these little robots and stick them at the end of their bar and next to each other, kind of like how they sat in Cheers, in the TV show Cheers. And people would refer to them as the dudes from Cheers, or Norm and Cliff. And these two guys sued, claiming that it was a commercial likeness. You're exploiting their likeness by their fictional characters that they played on TV. So you could not have made these, robots. Do you think they look like them? I think how it was set up, that was the goal. And the court said, yeah, you can't do that. If their characters are so intertwined if their identities are so intertwined into the characters that they play, that's what they're going to be recognized as. You cannot. So their characters are protected. The characters that they play are connected. But while we're on characters, let's think of it from the other end of the spectrum. James Bond. How many actors have played James Bond over the years? At least a half a dozen. Can any of those, Pierce Brosnan, Sean Connery, can any of those individuals sue in the event that an advertising company or a business in an advertisement tends to portray a hero in a suit, or an agent in a suit, and does all these antics and seeks out the nice ladies, that sort of thing? No, because it's not. James Bond isn't connected with any of their identities, and we're going to talk about a James Bond case in copyright. So, performer does not lose his or her right to control the commercial likeness, exploitation of his or her likeness merely by portraying a fictional character in a movie or TV. So they don't lose it. They get to make money off of that as well. All right. This is an oldie too. The Wheel of Fortune is still on TV. And this ad makes me laugh because this was an ad back in the early 90s where Samsung had this ad in the newspaper promoting their electronics, And basically they said that their electronics would outlast this longest running game show, which is still on, right? And it says, and this ad ran back in the late 80s, the case is in the early 90s, and it says 2012, right? This show is still rocking. Who is that? What's going on here? What's the suggestion? That's Vanna White, right? Vanna White wasn't happy. She sued for using her quote unquote likeness. Is she really using her likeness? It's like a robot with a dress and blonde hair. What prompts you to think that this might be Vanna White? How it's all laid out, taken as a whole, a blonde flipping letters that looks like part of the Wheel of Fortune board. She looks a little like C-3PO, I guess. Side note, can George Lucas sue for the use of saying, hey, that's C-3PO's likeness? No, because it's only an individual right. He might be able to claim some sort of copyright on that. But it didn't happen in this case. But point is, this is identity, an individual's right of publicity. So the argument here was, but that is my identity. That's what I'm known for, is flipping the letters on the Wheel of Fortune board. And everybody can connect with that. You see that and you think, Vanna White, Wheel of Fortune. Like, there's no doubt. It just pops in your head. Oh, look, Vanna White, Wheel of Fortune. And the court said, yes, identity, a use of a celebrity's identity can constitute appropriation. Now, do we have any problems with this? This is getting outside of the name. This is where disputes sort of kind of were coming into play, or like the courts are going too far on this right of publicity, because we got name, we got likeness, we got the TV characters that they are so intertwined with and can be recognized, but their identity? Here's another case on identity. You familiar with Johnny Carson? If not, just run a YouTube. By YouTube, he was a nighttime host, kind of like, Letterman and the other folks who are on at night. I don't stay up that late anymore. But he was a nighttime talk show host, and Ed McMahon was his sidekick. And before Johnny Carson came out, Ed McMahon would yell, "Here's Johnny," and you could totally see that. If you're not familiar with that, just Google it, take 5 seconds so you can watch it. And he was that host for well over 30 years, or maybe he retired at 30 years. But that's how he was always introduced. And whenever, people would mock and people would say, "Here's Johnny," and it wasn't Johnny Carson who was saying it. And here comes a toilet seat manufacturer who uses the slogan, "Here's Johnny," in their advertisement. And Johnny Carson sues. Not using his picture, not using any likeness of him whatsoever. He's not the one that says it. It's Ed McMahon who says it. But the court said, yeah, that's so associated with Carson's identity, you can't use it. You have to get his permission. Are we crossing the line here, or does that sound about fair? I think it sounds, in those cases, those celebrities are so intertwined into those things, you just recognize them. If I grew up in the time of Johnny Carson, and if somebody said, "Here's Johnny," we all knew where that came from, and we all knew who it was associated with. Here's just kind of a continuation of that story. So Johnny Carson passes away in the 90s, late 90s. That toilet seat company starts to use the "Here's Johnny," and they try and register it for a copyright. And Carson's family sues, and his argument is, Johnny's dead. There's nothing to associate it with, so to speak. And because Johnny Carson was a resident of California, the right of publicity carried on to his heirs for 70 years. And he was also precluded from registering it in the trademark for under the same purposes, that it was somebody else's mark. So it was even considered a trademark at that point. Even though it wasn't registered, it was deemed that in the state world. So just wanted to finish the story. The toilet guy wasn't given up. So can you ever use a celebrity's likeness? Yes, you can. We already talked about it once at the beginning when I was talking about the human cannonball. Newsworthy, but you can't use an entire, the entire package. You can only use it for newsworthy substance, and depending on what it is you're using, you can't use the entire thing. If you're talking about, somebody's concert, or you can use their photograph, right? You can use their whole photograph. You put a picture up, Lady Gaga, she's playing in town tonight. You can use it, newsworthy. You just can't broadcast their entire livelihood like a concert. When else can you use it? The Major League Baseball Association loves to sue people for some reason. They have a lot of cases that are out there trying to protect right of publicity and copyrights and trademarks and all of that. Put this in context. These are trading cards. There's just two of them. One is Pete Rose. The other one is Barry Bonds, supposed to be Barry Bonds. But they're cartoons, right? And they have funny little sayings by them. They're kind of political, social commentary in some fashion. And the Major League Baseball Players Association sued, saying that you're using the players' likenesses, and you can't do that. And the First Amendment, or the Supreme Court said, yeah, but there's this kind of a First Amendment rule, okay? We have a use of a likeness. They're identified, right? I just told you who they were. Do we have a commercial use? Yeah, they're selling these funny trading cards, right? They're characters of some sort. But the question is, if the use has transformed the image into a parody, or in some way used the likeness as a vehicle for the expression of opinion or idea, then rights of free expression take precedent. But if it's reproduced and merely a literal translation, there's no protection. I have this rule in a later slide. So our first is, it's a parody. Right? Parodies or social commentary on important social institutions constitutes protected expression. So if you're this is like that, those cards are copyright. Those are works of art. So we're talking about works that are parodies, even though you're using a likeness of a celebrity, is fine. Or if there's some sort of social commentary that goes along with it, even if you might be making money off of it, that's okay. That's protected by the First Amendment. And athletes, I was going to save this one for the end, but I see it's up here, so I don't want to skip it. The use of athletes' names in fantasy football sports. Again, this was another area that the Major League Baseball team went after, because what are you using? You're using their name, right? Maybe their stats. I don't play fantasy sports. There's some money that's involved. You might win a prize. So the sports teams, the Major League Baseball particularly, said no. That's evasion. That's the right. You're using our name. That's a violation of the right of publicity. And the court, I think it was the Ninth Circuit Federal Court. This issue was not at the Supreme Court. They said no. That's fine. That's a incidental use. And I wanted to talk about incidental uses a little later, but it's an incidental use. They have to use your name, they have to use your stats, and it's not a commercial venture. And then I liked in that particular case, the court said, "Don't you guys make enough money already? You got to kind of pick on your fans." That was a kind of a side note from the court. So, First Amendment protections. We're going to talk about a few more of those. These guys. Have you seen these guys before? The Three Stooges. Funny stuff. I'm not going to be able to jump back to this photo when I move on to the next one. But this was a sketch drawing. It's really nice. I could never draw like that. I like this. And this fellow who drew this was selling these pictures. Okay? It's art. It's his copyright. Drawing. And this was the test that I read earlier. If a user has transformed the image into a parody, which we saw with the cards, or in some way used the likeness as a vehicle for the expression of opinion or idea, then the right of free expression is going to take precedent. But they can't reproduce or make a literal translation, okay? i.e. you can't copy it. You can't copy it. So now I'm going to show you what the dispute was over the three. All right, the top one is the photograph, right? The actual photograph that the individual was using to make his drawing. Maybe they're not in the same order, but their face expressions are exactly the same. And in this case, the court said, no way. This is not transformative. This is a copy. This is a copy, and this is not fair use. You can't do that and then sell them. Okay, so this was an invasion of the Three Stooges' right of publicity. And then there's this photograph, which is hard for me to grasp off and blow up here, but that is Tiger Woods at one of the Masters that he won. The other individuals that are kind of kneeling down are other famous golfers. The unique thing about this image, which you might not get off of here, if you want to maybe Google it, you can bring up a better copy, is this individual painted this picture. And they weren't posing for him. This isn't like the Three Stooges. Oh, look at this picture. I'm going to copy it by painting it. He painted it out of his head. Like it came to him. He was watching the Masters, and that's what he took away, and he painted that. And in this case, the court used that transformation test and said this was transformative. He was selling these paintings. He had them reproduced, and he was selling them. And this was deemed transformative. Tiger Woods sued, by the way, was the one that sued and said, you're using my likeness. And the court said, no, this was free expression. So this copyrighted work was okay to use, even though they're using the right Tiger Woods in it, and he potentially has a claim for right of publicity. But the artwork was protected by the First Amendment. Comic books. Let's talk a little bit about comic books. Those are copyrighted works. When people create comic books, they fall under the copyright realm. And the individual here who created this, Todd McFarlane, who created a comic book involving a character whose name was Anthony Twistelli. He had first appeared in a comic book as the villain. I think the comic book's name, oh yeah, there it is. The comic book was Spawn. And later he was telling fans that he modeled his character, who's that nasty guy with the glasses on, after the famous hockey player Tony Twist. And he actually started referring to the character as Tony Twist. And the real twist was hockey player St. Louis Blues. He sued McFarlane after discovering that comic book version of him. And the case went to trial. The first award, by the way, was $24.5 million, and then $15 million, and then ultimately, after much dispute over how much had to be paid out, they settled on $5 million. And this, well, you might be saying, whoa, They don't even doesn't look like him. The question was the name. The villain's name was Antonio Twistelli, and then they started calling him Tony Twist. And then you have the actual author saying, "Oh yeah, I modeled him after the hockey player," or using the name of the hockey player. But really, it doesn't even remotely look like him. And this is out of the state of I want to say Wisconsin. So here, the court took a different approach from that transformation case, but the transformation rule is the rule that we are going to use that's the majority rule. This one that I'm going to tell you about, this comic book, I'm just going to let you know it's out here if you're into drawing and doing comics and so forth. This only exists in Wisconsin, is that rather than using the transformation test, is it so transformed that it's protected by free speech, they used a predominant commercial use. And if it was more to make money, then that's going to trump. And in this case, they were selling comic books, so it was a business venture versus an artistic venture. And it was Missouri, the Missouri court, and that is the minority, and that's probably the only state that uses that. So transformative test is the one you have to be aware of. Another one that imposed the transformative test. This is another comic book case. The other end of the spectrum using the transformative test. A little background. DC Comics gets sued for the Jonah Hex comic here. And they are sued by these two brothers, the Winter Brothers. They're a music band out of Texas. I've never heard of them. Maybe it's not my style. But you see the villains on the cover of the magazine, the one with the hat and the one's kind of the cigar. They're claiming that DC Comics used their name and their kind of likeness to create these two characters. And the names of these two characters in the comic book are Johnny and Edgar Autumn, and the two brothers are Johnny and Edgar Winter. Play on names? I don't know. But the court said, no, this isn't a literal copying. This is transformation. This is art. This is going to be protected by the First Amendment. Avatars. Video games, avatars. Right of publicity and copyrights going hand in hand here. Video games are protected by copyright. Here we have Lindsay Lohan is suing, and I have another slide. If you printed it out, you can probably see the other slide right after it. I'll click to it. But Lindsay Lohan and Karen Gravano, who was on some Mob's Wives. One of the reality shows, Mob Wives, is what she's on. They both sue, claiming that Grand Theft Auto are misappropriating their images as these avatars. And this was a New York case. So this is the one that's Lindsay Lohan. This is the one that's Karen Gravano. I don't know, but the question was whether or not these avatars are transformative. The New York court actually just dismissed the case upon its filing. There was a filing from both of these, and the defendants, the one who created the Grand Theft Auto, made a motion to dismiss, saying there's no claim for right of publicity here, and the court agreed. These are just images of regular women. I can't see that there's even remotely likeness. In Lindsay Lohan's a blonde girl in a red bikini. So the court ruled, one, there's no real recognition here, but number two, it's transformative enough to protect it under the First Amendment. And one more point here, the public domain material that we're going to cover. I'm probably going to revisit this image when we're done talking about the public domain. Let me click to the photo. This is going to help me explain that answer. Material that's in the public domain, as you're going to find out in the next lecture. Anything created by the government is in the public domain. We'll talk about the whys next time. But this photograph is in the Library of Congress. It was taken by the photographer for the President, Richard Nixon, who you see in the photograph, who's shaking hands with Elvis Presley. Now, Elvis Presley, even though he is dead, there's still a right of publicity that his heirs have on his likeness. Now, if you were in the Library of Congress, you're creating some documentary on Nixon, the Nixon administration, and you're going through public files, and poof, you come out with this picture, and you want to use it in, your documentary or your book or whatever it is you are doing. The question is, can you feel the question coming? Would you get in trouble, right of publicity, if you used Elvis's photo in the book or your work? And if you think through some of the exceptions we have, you might have, depending on what you're doing, and is it newsworthy? That get it out of the exception. Is it a different form of art protected by the First Amendment? Is it transformative enough? Is it an incidental use? We talked about incidental use relative to the fantasy football. Is it incidental? So the question becomes how you're going to use it. I can't give you a yes or no, but I would think that if this is a minor thing dropped into a bigger project about Richard Nixon, it's going to be an incidental use, versus if maybe you were doing something about Elvis Presley. But if you were doing something about Elvis Presley, you would need permission altogether, depending on the direction of what you were doing. And we'll talk more about this stuff. I just wanted to put it out here. One more note: we talked about the comic books, and we talked about photographs, and we talked about avatars. Let's talk about music real quick, using a name in a song specifically. Again, Lindsay Lohan loves to sue people. I guess she can't get into the movies or make money other ways. She sued Pitbull, who had that song "Give Me Everything." The line in the song is, "So I'm tiptoeing to keep flowing. I got locked up like Lindsay Lohan." She sued. Use my name. Use my name. Well, that name, but yeah, he's making money, right? There's a commercial component to it. He's making money off that song. But do you think he's making money off that song because of Lindsay Lohan's name? Right? You're not going to go out and buy the song and be like, "Oh yeah, he's got this line about Lindsay Lohan. It's the best song ever." No, you buy it because it's the song. It's incidental. That was an incidental use. Okay? So I think that covers our right of publicity. We are going to start the introduction to copyright law.